topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show. You know, when it's a live show, you don't get to see a lot of things that happen backstage. Today has been crazy, and thanks to my great producer, she's talked me through it. I could have never done this myself. In fact, I almost didn't make this show. We have got a great show for you. We are also on TikTok, and we are live on TikTok. And I don't remember, Kirsten, if we were on TikTok last time you did our show, but we are also live on TikTok now, and we're going to be talking about community association law. So if you live in a condo or an HOA, you're always wondering about laws, your documents. Gosh, today is the best show. Hey, good afternoon, Kirsten.
Hello, Steve. How are you?
How you doing? I love doing your show. I got to tell you, I don't know if Jeff has told you, but your numbers are insane. They are crazy between just YouTube and TikTok. You have developed such a large audience.
That's awesome to hear. And to your question, I don't know if we were on TikTok last time. I think that was, you had announced it, but I don't believe we were.
Okay, so I'm seeing a different background today. Where are we at today?
Yes, I'm just at a different office location. It was either that or being in the car.
Oh, gosh. No, we don't want to do that. So, Kirsten, we've got all these new people watching on TikTok, and I get to see the numbers right here. Tell people about K. Bender Rimbaugh.
Sure. So, K. Bender Rembaum is an exclusive community association law firm, which means that we represent your community associations consisting of either condominium associations, HOA entities governed under Chapter 720 of the Florida statute, and then cooperatives governed under Chapter 719 of the Florida statutes. I mean, we have multiple locations throughout the state. Our main office is in South Florida, in Pompano Beach, but we have grown and expanded, and we have offices in Palm Beach Gardens, in the Orlando area, and then I am a managing attorney of the West Coast office for the firm, which is located in Tampa.
Well, I got to tell people this. This is kind of a behind the scene. This show is so easy to do because of you, our listeners and viewers, because you write in the questions and it makes it so easy. We don't have to come up. I could never come up. After doing the show for 15 years, I still couldn't come up with my own questions. So you, the viewers out there and listeners, make it so easy. And I got to tell you, and I guess, Kirsten, you know, we had pages and pages of questions. I got to tell you, community association law is so popular. I cannot believe it.
Yeah, I don't disagree. I mean, when I don't know if the audience knows this, but we try to look. I try to look through all the questions in advance, and like you said, sometimes we get pages and pages, and it's impossible to answer all the questions. So we try
Exactly.
to pick, questions that touch generally on the variety of topics. So try not to focus on just one particular issue, because there's just so many issues in the condo HOA world, from corporate governance to use restrictions to assessments, and the list goes on. So we try to do our best to answer as many questions as possible.
Exactly. In fact, we will not be taking questions today from TikTok audience. A lot of people are writing questions in. Between all the questions we get in from month to month for Kirsten's show, first YouTube questions that come in, we just can't get to them all, and we apologize, but we appreciate you taking the time. Kirsten, I'm going to tell you something. You're too busy taking care of your clients, so you don't know this, but you would not believe all the law firms that are adding on their shingle all over the United States, community association law. They can have bankruptcy, criminal law, PI, family law, and they're adding community association law, which is different for K. Bender Rimbaugh, because this is all you do.
That's correct. This is our bread and butter. This is what we do 24/7. We don't practice any other area of the law other than community association. Obviously, there's real estate, and there's many facets to this practice area, but our primary focus is guiding our community association clients, board of directors, in operating and managing their associations.
Well, I got to tell you, after doing this for 17 years, I've learned that when a law firm specializes in one area, that they always turn out to be top of the top, the creme de la creme. And that's what K. Bender does.
Yeah, I mean, go ahead. Yeah, let's go straight to the questions.
Okay, we're going to start off with Barry in Tampa. Let me just make sure, because I want to make sure that I've got my questions right. I think Barry in Tampa is I'm in a HOA, and please, when you write your questions in, let us know if you're a condo or an HOA. I'm in an HOA where the developer is the board. The board put in writing with violations that after first notice, they will send it to an attorney if not corrected. No other notices, no fining committee, just to a lawyer. Is that legal?
It's not illegal. And I hate using the word legal or illegal. But what Barry needs to understand is that, fining and suspension of use rights, these are just some of the alternative remedies that an association board has to enforce a covenant or rule violation. These are not the exclusive remedies. They're just options. And the board has the discretion to decide how they want to enforce a covenant or rule. It might be that fining or suspension of use rights is just not a viable remedy for a particular association. Especially when, both HOA and condo statutes have very specific requirements that boards have to follow in order to properly fine, including that you have to have a separate committee of at least 3 members who are not on the board, not officers, and not employees of the association. And for many communities, that might just not be a viable option. So there's nothing inherently wrong in the board choosing to just refer a matter violation to their legal counsel for further enforcement.
I got to throw this in because you never know who's watching or listening. We just got a hello from New York. They have a condo in South Florida. They want to know, what is the liability of the association president of a condo association gets a key to access everyone's unit without anyone knowing?
Well, it's not unusual for an association to have copies of unit keys, right? And in fact, there are many associations that require owners to provide a copy of their unit keys to management, so that the board and management have the ability to access units under certain conditions. In Florida, under the Condominium Act, boards or associations have an irrevocable right to access units under certain conditions, such as in case of an emergency, right? For example, if there's an active water leak, right? The management boards have to be able to go into a unit to determine the source of the leak and try to stop an active leak. Or in connection with the maintenance obligations of an association, right? The declaration typically outlines the maintenance obligations of the association, which may include common elements that might be within the unit, whether it's drywall or certain types of piping, right? We always recommend, though, when the board needs to have access to a unit, that it be done in a certain fashion. That you have typically a police officer present. That you document the entrance and the exit of the unit to minimize that liability and exposure to the association.
Let's go to Phil in Tampa. He wants to know, are there any documents that aren't allowed to be seen by the owners?
Yes. So under both 720 and 718 and 719 of the Florida statute, there is a list of records that are not accessible to unit owners, right? So that means that while these records are part of the official records, if an owner makes a request to inspect them, the board can deny access to these records. And these records generally include, and this applies for both HOAs and condos and co-ops, but typically records that are protected by attorney-client privilege, those are exempt from inspection. So, for example, if the association has legal counsel and legal counsel has given a legal opinion on a particular issue, that opinion is not accessible to unit owners. Of course, with attorney-client privilege, it's the client, it's the board of directors that has the ability to waive that privilege, but ultimately business decision of the board. Records related to the sale, lease, transfer, approval of an association. So this might come into play if the association has the ability to approve or disapprove prospective purchasers or tenants, right? And as part of that application process, typically the board will request an application and then run a background check on the applicant. So all of that documentation, including the background report, right, whether it's the criminal report or the credit check, all of those records are required by statute to remain confidential, which means the association cannot provide it and should not be providing it, not even to the applicant or the owner of the unit that's looking to sell or lease the unit. Personnel records of association or management employees. So those typically include records related to payroll, disciplinary, health, or insurance records. Those are exempt. However, I do want to point out that personnel records does not include a copy of the management agreement with the association or an employment agreement between the association and the employee, or any records that identify the compensation of the employee. So owners are entitled to see what the employee's compensation is. Medical records, those are exempt. And those might come into play, for instance, if an owner or resident is making a request for accommodation and they provide any documentation related to their medical condition. And then, things like, social security numbers, driver's licenses, any address that was not provided to the association for notice purposes, email addresses, unless the owner, of course, has consented to receiving notices via email. So these are the typical records that are exempt from inspection.
Okay, I'm dying to ask this question. This is not in your market. This is in the Delray Beach area. I'm not even going to name the complex, but they've had. You're gonna laugh when you hear this. They have had 130 arrests at this, and it's a I think it's a condo association. 130 arrests in the last year. Can people find out what those arrests were for that live there?
Well, I mean, typically arrests are a matter of public record.
Right.
So those definitely are not exempt, at least under the statute. Yes, that's just a public record. Yeah.
I don't know if I'd want to live there with all those arrests going
insane.
on. And it's a 55 plus too, on top of that, which really makes it kind of strange. But anyway,
Right.
let's get back to our questions. Jen in St. Pete, is it okay for a president to create a code of conduct for the board? That's interesting.
Well, codes of conduct are not unusual and certainly recommended. I've been to many board meetings that are just crazy, right? With some unusual board members. I'll just leave it there. So, code of conduct would be very beneficial to the board. Certainly the president can assist in drafting one or can assist, propose one. But I think ultimately the board is going to have to review and then formally approve the code of conduct.
Here's one from YouTube. Our HOA management company was bought and corp dissolved. We still have old contract with old name of the company. Should we be concerned?
They have contracts with the old name of the management company that was dissolved?
Yes.
It's not unusual when entities are either merged or bought out by bigger entities. Typically there's a clause in a management contract or, contracts in general that allow assignment of contracts under certain conditions or might prohibit assignment except under certain conditions. So I would suggest maybe taking a look at the original contract. It wouldn't be unusual for a management contract to allow assignment, especially under circumstances like this, like a merger or a company being bought out. And so the contract remains it remains valid and can still be enforced by the new management. I guess an option remains for, the board can always contact the new management and maybe just, negotiate or enter into new agreement under the new name. So that's an option.
Here's a question about K-Bender Rimbaum. Does KBR advice extend to guiding association proper, not for proper corporation regulations and procedures?
You broke up there, Steve. Does K-Bender guide associations in like corporate governance matters?
Proper, not-for-profit corp regulations and procedures.
Yes. So, associations are generally corporations not for profit, which are governed under Chapter 617 of the Florida statute. And so whenever we advise associations regarding any corporate governance issue, we certainly also look to Chapter 617 in addition to 718 or 720, just to make sure that, there's no conflict between the statutes. So absolutely.
Okay. So, boy, we get a lot of questions about parking. This is from Cecil in Tampa. What is the correct way to change the rules on allowing trucks in the community? Right now, we do not allow trucks, but we have guests that visit or rent for 3 months with a truck. What do you advise?
So it's unclear if the if Cecil is when the caller is referring to a rule, if they're actually referring to the rule or potential or a covenant in the governing documents. If this is a restriction that's contained within the declaration, whether it's the declaration of condominium or declaration of covenants, if you're in an HOA. And by the way, that is the supreme document, right? So in terms of the hierarchy of the governing documents of an association, which include the declaration, the articles and the bylaws, the declaration is going to be the supreme document because that is essentially the contract between owners and the association, right? And so if the covenant is in the declaration and the declaration currently prohibits trucks and the board wants to allow trucks, then you will need an amendment to the declaration to, remove that restriction. If you have a declaration that is actually silent and doesn't specifically restrict trucks, and you have a rule that restricts trucks, well, I would say that rule potentially conflicts with the declaration. You might face enforcement challenges if you're trying to enforce a rule, because one of the enforceability rules in Florida, in order for a rule to be enforceable, it cannot conflict with the declaration. So I would check first where the restriction is. Is it in the declaration or is it in the rules? And if it's in the declaration, then that will likely require an amendment. If it is in the rules, it's likely an unenforceable rule, but I would still delete that restriction from the rules.
We still get a lot of questions, Kirsten, about parking for handicap. People want to know what can they do? Is it through the association in order to get more handicap parking spaces?
Yes. I mean, if an owner is requesting a handicap parking space, that's definitely a process that you'd have to go through the board. And then I would counsel the boards to then seek legal guidance on how to properly address that request. Mm-hmm.
Okay. Now, one of the other things I love about K. Bender Rimbaum is you put on so many free classes every month. You teach many of them. What classes do you have coming up this month?
Sure. Let me see here. I have a scroll. June, July, those are the summer months. So typically, our snowbirds leave the state and it's usually quiet, but June is pretty busy for us. So May 27th, which is Wednesday, tomorrow, we have an HOA board member certification class. That's a webinar taught by my colleague, Ellen Schwartzite. Then also, so that's at 11. Then tomorrow at 3, there is also a webinar, HOA meetings, notice requirements, participation in elections. So Alan is also teaching that one, and that one's going to address, anything related to noticing your meetings, owner participation, owners' ability to speak at these meetings, right? That's always a question. Can owners, speak and ask questions at meetings? And then he'll go over the election process. Then on Thursday, May 28th, I'm teaching a webinar on HOA financial literacy and transparency. So we'll talk about all things financials, but only focused for HOAs governed under Chapter 720. Then Friday, my colleague Emily Gannon out of the Pompano office will be teaching a webinar on guest restrictions, screening tenants and owners. So that's a really good class. She'll talk about basically the process to screen applicants, as well as the authority to do so. And if you don't have authority, she'll walk you through what you need to do to have the authority to run background checks on applicants. Then June 10th, Danielle Brenner, my colleague from the Palm Beach office, will be doing a webinar on HOA record keeping and records access. So all about, record retention and inspections for HOAs. June 17th, my colleague Lisa McGill will be doing a webinar on the condo board member certification class. Then June 24th, I will be teaching a condo board member certification class with Alan, and that's that 4-hour certification class. Then June 26th, I'm going to be also teaching the HOA meetings, notice requirements and elections. So if you can't make to the one that Alan is teaching this week, end of June, I will be teaching the same class. And then Alan is also teaching a condo board member, the annual CEU class. That's June 29th.
Wow, busy month.
It is for a summer month.
Yes. Tell people before we go to break, how can people reach K. Bender Rimbaum?
So you can reach any of our offices through the main number, which is 954-928-0680. And then depending on the attorney you wish to speak with, you'll just be transferred to their particular office. And my email is khenze@kbrlegal.com.
Beautiful. We're going to go to break. When we come back, we have more with K. Bender Rimbaum and attorney Kirsten Hens. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
And we are back. This is the last Tuesday and Thursday of the month and the first Thursday of the month. We do our K. Bender Community Association show, and it has been running for about 15 years now. It's amazing. We've got built up such an audience. People have so many questions. Today we are with attorney Kirsten Hens. Wonderful, wonderful guest. Let's get to our questions. Let's go to Sal in Tampa. He said, would you please touch on process of elimination of smoking in common areas?
Yeah, so smoking in the common areas or the common elements, if we're talking about a condominium, that can typically be done by a board adopted rule, provided the board has the authority to adopt rules in the governing document. So typically boards have the ability to adopt rules regarding the use of your common elements or common areas and facilities, right? Like use of pool, use of your gym. And so as long as you have that authority, adopting a rule that prohibits smoking in these common areas typically is within that purview. And so, I would, it can get tricky. So I do recommend getting with legal counsel to draft a rule to prohibit smoking, and then follow proper procedures to duly adopt the rule at a board meeting.
Okay, let's go to. We get so many questions about Zoom meetings. Here's from Barb in Tampa. What are the rules if you decide to have a Zoom meeting?
Yeah, so I mean, certainly Zoom meetings have become a thing since COVID, right? It was initially something that boards were able to do under the emergency powers, right in the height of COVID. And then those emergency powers disappeared, and then boards just continued to have these Zoom meetings because it was very flexible, right? And so, the issue was always, or the question was always, can the board just have a Zoom meeting, or do they have to provide some kind of physical location for a meeting? Well, that question has been answered, at least for condominium associations. So if you are in a condominium governed under Chapter 718 of the Florida statute, the statute was modified last year, which now allows board meetings, committee meetings, membership meetings to be conducted via what is referred to as video conference, which is essentially your Zoom and other virtual platforms. But if you are going to conduct a virtual meeting, and that is ultimately a business decision of the board, so you don't have to, but if you choose to, there are certain requirements in the statute. One of them is that on the notice of the meeting, you have to include a hyperlink for the Zoom, as well as a call-in number for owners to be able to call in if they're unable to access Zoom via the web. The notice, importantly, has to include a physical location for the meeting. So you no longer can get away with just having a virtual meeting. There has to be on the notice an address, a physical location. Even if it's a physical location where only the property manager is going to be sitting, but you have to give owners the options to attend the meeting in person. And then also know that virtual meetings have to be recorded. And then those recordings have to be maintained as part of the official records. And if you are subject to the website requirement, you will also have an obligation to post a copy of that recording on your website. So those are the requirements, but only as they pertain to condominium associations. There's no similar requirements for HOAs under 720.
Okay. Here's a nice one. This is from Kenny in Tampa. I am the president of our board. I really enjoy watching your show every month. In fact, we hope to get together with you in the near future to represent our group. That's a good one. Can you tell me what percentages of disputes that you settle instead of going to litigation?
What percentage of disputes that we settle specifically,
Yes.
or that are generally settled?
Well, it says disputes are, well, actually, it says what percentage of disputes are settled instead of going to litigation. So it doesn't really say K Bender.
Yeah.
Sounds like in general.
I mean, it's hard to know, right? Because ultimately we don't have a record of those disputes that end up settling, right? Because they never end up either in court because they're settled outside of court, or if a lawsuit is filed, they're ultimately resolved. But I would venture to say that more disputes are settled through pre-suit mediation or some other informal mechanism outside of court than actually end up being litigated.
Okay. Kathy in Tampa, for an HOA, the board passed a special assessment for major clubhouse repairs. An owner believes that the governing documents require an owner vote. The board disagrees. What are the owner's options?
What are the owner's options? Well, I would first say, please review the governing documents and confirm that the governing documents in fact require the board, member approval on a special assessment. The caller said the assessment was adopted in connection with clubhouse repairs. So if we're talking about, necessary maintenance repairs, right, then even if the documents require membership approval for a special assessment, there is case law that basically says that if the assessment is being adopted in connection with the necessary maintenance obligation, then the board has a fiduciary obligation to adopt the assessment and do the repairs without getting membership approval. If we're talking about, capital improvements, that might be a little bit different. And so if the caller feels very strongly about this topic, then I would urge her to get, seek the advice of legal counsel before she files anything or proceeds further.
This is from Norman. Pickleball has become so popular. Actually, where we live, it's more popular than tennis courts. Is it difficult to get the board to put in pickleball and get rid of some of the tennis courts?
Well, you know what? As a side note, for years I've wanted to learn how to play tennis. For one reason or another, that's never come into fruition. So I just went straight to pickleball. And it is so much fun. So I totally get it. Well, when we're talking about either adding, pickleball courts or changing the existing tennis courts to pickleball courts, right? We're talking about some form of alteration to, the common elements or common areas. Now, the caller didn't indicate whether they're in a condo or an HOA, right?
Yeah, they did not say.
Right. So, with a condominium, that becomes a question of whether this change is the material alteration to the common elements. And, without looking at anyone's governing documents, I would venture to say, yes, it's a material alteration because it changes the appearance of the existing common elements. And so that will typically require a membership approval. Now, under the statute, the approval that you need to get is 75% of the owners, unless the documents say something else. So then you'd have to go and look at the governing documents to see what membership approval percentage is required to make an alteration to the common elements. With HOAs, that's a little bit different. Material alteration is not a concept that's in the statute, but there might be restrictions in the governing documents of the HOA. So you would have to take a look at that to see, what membership approval requirements exist, if any.
Okay. Molly in Tampa, we are an HOA. We only have 2 board members, and we can't get a third board member. How do we get anything done to our property? We get a lot of questions like this. We have tried so hard to get a third board member. We can't trim the trees or do pressure wash. What do you suggest?
Well, I guess my first question is what is the size of the board? What do the bylaws require for size of the board? Do the bylaws provide a specific number? Board has to consist of 5 directors or 3 directors, or does it provide a range? And so that that question is important because in order for the association to operate, in order for the board to be able to conduct business, right, hire the vendors, and really conduct any other business, you need to have at least a quorum of the board present at a meeting. So if you don't have at least a quorum of the board, quorum means, the minimum number of directors necessary to conduct business, right? So if you don't have the minimum number, then you can't proceed with any agenda items. And so, if the caller's saying they only have 2 directors, they need a third, well, is the size of the board 3? Because if the size of the board is 3, then quorum is 2, then conceivably they might not need that third director. If they're saying they need the third director because the size of the board is required to be, 5, then that's potentially problematic. I would, in that case, send out notices to the membership, trying to get volunteers to serve on the board, and let them know, listen, this can be a problem. If you can't fill enough seats on the board to have a quorum, then you potentially subject yourself to a receiver, right? And receiver is basically a third party that a court appoints to conduct association affairs until the board can get their act together, right? And it can cost a lot of money. So if you want to avoid receivership, then, really try to get that seat filled.
It's amazing because we get all these questions. A lot of them are complaining. And I just wonder, instead of complaining, why not run for the board? It seems like there's a lot of associations that would love to have new blood come in. Isn't that right?
That is true, but you'd be surprised. Sometimes the complainers actually try to run for the board and don't get elected.
Oh.
So that happened as well.
Yeah, it works both ways. Let's see. Can a non-owner be allowed to attend our condo election meetings? I don't know why they want to.
Yeah, so really any meeting of the association is typically reserved for the unit owners, right? Or if an owner has has given a power of attorney to that authorized, attorney in fact. So typically those are the individuals that are entitled to attend a meeting, unless of course the board wants to invite other non-owners to attend. So it's within the discretion of the board.
Jenny in Tampa said, Kirsten, I love the way you respond to the questions. I love your show. Can we do our annual and our budget on the same date?
Yes. I mean, conceivably, you can have your budget meeting, which is the meeting in which you're going to adopt the budget, and then have your annual election meeting on the same day. Practically speaking, I would suggest having your budget meeting before the annual meeting, because at the annual meeting, the board can change, right? And so, alternatively, you'll just postpone the adoption of the budget for another time after the election.
I don't think in all the shows we've done, Kirsten, I don't think we've ever had a marijuana question, but here's one from Jack in Clearwater. He said, we have a no smoking amendment in our docs. If I have a prescription from a doctor saying I need to smoke marijuana, would I be in violation of my docs if I smoked inside my unit?
Well, I'm going to presume that the amendment prohibits smoking in units, and typically the board wouldn't be able to prohibit smoking in units unless there is a restriction to that effect in the actual declaration as opposed to a rule. But if there is a no smoking restriction in the declaration and an owner or resident has a medical need, for the marijuana, or they can always request a reasonable accommodation, right? Just like, pet restrictions, and then an owner has a service animal that they want to keep or maintain in the units in violation of the pet restrictions. Similar process, you would request an accommodation and then go through that process to support your need or disability related need for the marijuana.
Sybil in Tampa wants to know, what if a quorum at an annual, what is the quorum at an annual meeting for HOA? If we can't get a quorum, does the old board roll over?
Yeah, so for HOAs, the statute says that quorum of the members consists of 30% of the voting interest, unless, of course, your bylaws provide for a lower percentage. So, check the bylaws to see if they provide for a lower percentage. And some bylaws do. Typically, I've seen it 10%, 15%. If not, you default to what the statute provides, which is 30%. Provided you have, quorum, you've established quorum at the membership meeting, you can proceed with the election. If you cannot establish quorum, then correct, the existing board members, they will just roll over for another term.
Let me get this is our last question. Cheryl from Palm Harbor, must be Harbor. Is an HOA, if I'm delinquent, can I still run for the board?
So with HOAs under Chapter 720, if you are delinquent in any monetary obligation owed to the association, so that includes not only assessments, but fines, interest, attorney's fees, any monetary obligation whatsoever. If you're delinquent on that, on the last date by which you're entitled to nominate yourself, then you're not eligible to run for the board.
Well, I guess that's going to wrap up another one for the month.
That went so fast.
Well, you're just really good at what you do. And we had so many people wanting to come on and ask questions from TikTok. Eventually we will do that. It's just there's so much moving parts on this show. Kirsten, one more time, tell people how they can reach your office.
Yes, the main number of the office is 954-928-0680. Thank you, everyone. Thanks, Steve.
Thank you. We'll see you next month, Kirsten.
Will do. Bye.
That's attorney Kirsten Hans. Amazing. Hey, folks, if you're on your board, I got to tell you, if you want to have the creme de la creme when it comes to a law firm that just handles community association, K. Bender Rimbaum, they have offices throughout the state of Florida, and they do many shows with us. That's going to wrap it up for us today. For TikTok, we'll be back again with you tomorrow. And for everyone else, we'll see you next month. Thank you so much for tuning in.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.